A story in the New York Times last month details a big problem for families who choose to put their loved ones in nursing homes. Many nursing facilities are now including arbitration clauses in their contracts, meaning if something happens to your loved one, you cannot sue for damages. Arbitration clauses have become very popular over the last decade, being included in everything from cell phone and credit card contracts to student loans. Nursing homes, though, in particular, have been including them in complex contracts that most people don't really understand when they're signing. So how do you navigate those contracts? What do you do if a nursing home has a clause in their contract? Here to explain it all is Yao Dinizulu, a personal injury attorney who's handled many of these cases. Yao, it's good to see you again. So first of all, how prevalent are these clauses?
Well, it's become a lot more prevalent over the last 10 years. It's been in other types of businesses, and now it's moving into the nursing home because they see a strategic advantage in order to basically get one over some of the residents.
They're trying to cut costs, right?
They're trying to cut costs. They're trying to bring down, put a veil of secrecy on the types of cases or the types of behavior that's happening in the nursing homes. So they don't want it in the public system, and so they're trying to sideway them into a private system that is not available for public sight.
Okay, so if you discover, most people don't even know they signed it, right?
Correct.
Yeah, they go into it, they sign what they sign and say, whoa. So if your loved one has a problem and you have signed one of these clauses, what are you going to do?
Well, first of all, you need to contact an attorney.
Yeah.
But in Illinois, we have the Supreme Court has basically said there's two different ways in which a person can get damages for their family member. One is if it's under a survival count. Another one is if it's a wrongful death. The survival count in Illinois basically says that these arbitration clauses are valid. But in the wrongful death claim, you can get away or avoid utilizing the arbitration clauses.
All right. So what do you advise folks who are searching for a nursing home where they feel like they want to, they want to make sure everything is good and that their loved one is going to be safe and taken care of? What did they discover that in the fine print they have one of these clauses? Can they try to negotiate their way out of it, or what should you do?
Well, it's kind of a form contract. A lot of the nursing homes are not allowing you to make those changes to those contracts. So basically what you may need to do is look at other nursing homes. And one of the things you can do is you can ask their administrator whether or not they have these types of clauses. You find out about the specific care being provided at that facility.
All right, so what if somebody's out there and, God forbid, something happens to their mom or dad in the care of these folks where you have signed such a clause in the initial agreement? Really and truly, do you have anything you can do at that particular point?
Well, they absolutely still have a claim, and it can possibly still be brought in a civil lawsuit where you have the rights of a jury. However, you really need to seek counsel to understand how that arbitration and clause will affect you. Sometimes it will, or more times than not it will, and other times there are exceptions that a trained attorney can help you navigate.
So bottom line is, make sure you know what you're signing.
Absolutely.
Yeah, thanks very much. We appreciate you coming in.